Jonathan Lee Riches investigates. I am covering the Moscow, Idaho Bryan Kohberger case. Former U.S. Congressman and legal expert Trey Gowdy speaks about the Bryan Kohberger case. And he has some interesting insight about the standing silent and also about Bryan Kohberger standing silent at his arraignment for his indictment. But he also talked about possibly Bryan Kohberger maybe down the line will seek a mental evaluation. And, that's a possible theory. And he talks about how defendants do that to try to get more of a favorable sentence. But I'm going to play the clip right here and then we'll further discuss.
We'll start with a question from Marianne in Idaho. And she writes, what is the strategy for Bryan Kohberger standing silent and not entering a plea?
Are you listening very carefully?
Yes.
What is the strategy for Bryan Kohberger standing silent and not entering a plea? That's the question?
That's the question.
All right, here's the answer. There is not one. There's no strategy. The only possible strategy is if he is going to try and pursue some mental health defense, either at trial or sentencing. And even though I don't think the death penalty has been announced, and I have no way of knowing what the prosecutors are going to do or should do, but it is certainly a death penalty eligible case. So they are treating it like it is a death penalty case. And they may pursue a mental health defense at trial, which is during the guilt phase, which is where you determine whether or not he committed the crime. And then at least in South Carolina, and probably in most jurisdictions, there's a separate phase, a separate trial, which is the sentencing phase or sentencing trial where you determine what the punishment is. And you can pursue mental health defenses at either or both. I think what's important for folks to remember about the entering of a plea, it's just a formality. The entering of a plea upon being indicted is simply a formality. I have been in courts before where the defendant was going to plead guilty. We knew he was going to plead guilty. He told us he was going to plead guilty, and he still sat there and said not guilty. That's what they all say at that phase. Even if you know that tomorrow you're going to plead guilty. Now, you may say, well, why? Well, I've also been in courtrooms where the judge that is presiding over that hearing or that proceeding does not have the authority to take the plea. So even if everyone in the courtroom wanted to plead guilty that moment, the judge that is doing what we call the grand jury returns or the arraignment or the initial appearance does not have the power to take the plea. So what he was doing in court, and I don't mean by formality, I don't mean it's not important. It's important that the charges be read to you. But whether he answers or not is completely irrelevant. I've had defendants that refuse to answer any questions. What's your name? Are you happy with your lawyer? Do you want to apply for the public defender? They don't say anything. I've had them where they just sat there and screamed at the judge. So the fact that he sat there and said nothing is utterly meaningless unless his trial team is going to try for some diminished capacity defense, and they don't want him answering any questions because they want to be able to try to convince a jury that somehow, and forgive me if my psychiatric terms are not right, they're not clinical terms, so forgive me. If he's off in the head, it's hard to convince a jury that someone is off in the head when they're answering questions put to them by a judge and understanding what's being said. So that's the only thing I can think of is they've told him don't say anything to anybody because we're going to try to save your life by convincing a jury that you have mental health issues. Does that make sense?
It does. Thank you so much for breaking that down for us, Trey.
Can I say one other thing? Not that you asked.
Of course.
You can fake being dumb, but you cannot fake being smart. So, it's fine that you have some defense attorneys that are now telling you, act like you don't understand the questions, act like you don't speak English. You go back, I don't know when they administered tests to you, Mary Langston, they probably didn't because they thought that you were like angelic and should not have to take tests. But for the rest of us, we had like the Stanford Binet or the Wechsler test administered to us, maybe the third grade, maybe the sixth grade. Mm-hmm. So you can go and get the numbers then as to what somebody's IQ is, their intelligence quotient. You can go get it when they're young. It's amazing once they're charged with capital murder and their lawyers go and get a psychiatrist for them, how poorly they perform on those tests. So just keep in mind, you can fake being dumb. So you can sit there when you're charged with capital murder and intentionally get every question wrong and try to convince people that something's wrong with you. But you didn't fake it when you were in the third grade or the sixth grade or the ninth grade. So those are the test scores that mean a whole lot more to me and probably to a jury as well. But that's why he's not talking, because his defense team is going to try to pursue some mental health defense, is my guess.
Wow, there's a lot to it. Well,
sense?
thank you. Yes, sir. There is a lot behind it.
Well, let's just start with my first sentence. It is utterly meaningless. It does not mean anything. And it's not going to work. I mean, he may not get the death penalty. They may not seek it, but it's not going to be because he stood silent when a judge said, how do you plead? I don't think that's going to sway anyone.
Always good to hear from Trey Gowdy, the legal expert, former U.S. congressman. Somebody in Congress spoke about the Bryan Kohberger case. But it is interesting because he said, defendants kind of manipulate, more or less said defendants, when they get this mental health evaluation, they can manipulate to get the results they want and then can use that as a strategy to get a deal. It reminds me of the other case in Latah County with John Lee. John Lee, a few years back, got a plea deal with the prosecutor who didn't seek the DP. Seems like after these kind of mental health evaluations got presented, and John Lee ultimately pled guilty to a lesser charge, second-degree murder, pretty much spending the rest of his life in jail, but he avoided the DP by using a mental strategy. Now, maybe he does have mental issues. I'm not a doctor or whatnot, but will Bryan Kohberger go that route? Lori Valadabel, another case where, they were seeking the DP, but I guess after further evaluating her mental status and whatnot and the delays in her case, the judge ultimately took the DP off the table. Could this be a strategy that Ann Taylor is going to do with the Bryan Kohberger case down the line? Let me know what you think about that interview. Subscribe to my channel, hit the notification button. I am covering the Bryan Kohberger case. Check out my Bryan Kohberger playlist. We'll talk soon. Stay tuned.